You could turn your phones on silent, put your tray tables up. We're going to have an amazing experience. And we're going to start right on time. So right now, we're about 2 minutes off, but we have our first speakers for KYC, Claudia Casalis and Serena Whittier. If they could please come up, and I believe Paul will be making some information with a roving mic from there. So why don't we start with a big round of applause, because everyone's too quiet in the morning.
Thank you.
Okay.
I guess I'll go here. Yeah?
Yeah, sorry. Went to the gym yesterday, not a good idea. Okay.
Hello, good morning, everyone.
Good morning. How are you guys?
It's just us, ladies. We all know you, you all know us. Claudia Casalis and Serena Whittier from Robert Allen Law are here to talk to us this morning about KYC and AML. And I think the best thing to do is to get started with asking you to define KYC and AML and how they apply to the yachting industry. Our world's changing. It's not something that was really a concern. It's not too many years ago, and now it's on the forefront of everything that we do. Claudia, why don't you start with us?
Sure. Well, we live in an ever complicated world. So at its most basic term, AML, it's anti-money laundering rules and regulations, and they basically differ from each country. But what they try to do is to minimize financial crimes and basically money or assets that are criminally obtained to exchange with clean assets. When it started in the US, it basically applied to mostly financial institutions, so you guys didn't have to worry about it. We're still there to a certain extent, but now basically US persons are required to not deal with US sanctioned individuals. So that basically means you have to do your due diligence. You need to know who you're dealing with. If it's a company, you need to know who the ultimate beneficial owners are. And basically you need to check that they have the financial. You don't need to look at statements, but you need to make sure that they are who they say they are, that they can send you wires, that their referrals are up to par. If you're in the European Union or in the UK, you have to do a lot more than in the US. See?
Claudia, can I interrupt and ask Serena, how do you find out who they are? How do you make sure? Where do you go? Who are you going to call?
Not Ghostbusters.
Not Ghostbusters?
No, not Ghostbusters. So basically, when you first onboard a client, unfortunately, you now have to ask them for a copy of their passport. If they're using an entity, you need to ask them for corporate documents to make sure who the shareholders are, who the managers are, and then run all of those people by, there's websites for, in the US, what we call OFAC, is the Office of Foreign Asset Control. And you can type those names and make sure that they're not sanctioned. The European Union has a similar website, and so does the UK. If any of the names pop up, you need to stop right there. But at least so far where we are, if they're not sanctioned individuals, and you're in the US and you don't deal in the European Union, you can probably stop there.
And I would also say make sure to keep going up the levels. If the owner is another entity, keep going up and keep asking until you start to get to actual people, actual persons.
Yes, so rule of thumb is, let's say a company has 5 shareholders, right? You should do what we call KYC, know your client information, for anybody who owns 20 or 25% of the company. What that means is copy of your passport, utility bill to know what their residential address is. If you were at a bank, or if you're a service provider in the Cayman Islands, you would probably ask for referrals, letters from their banks, maybe even a source of funds statement. I don't think you need to go as far as that, because you're not subject to the European Union rules and UK, but if you were, you would have to.
So I just want to interject as the litigator up here. Usually if you have to make a call to me, you're not having a good day. So how do you prevent getting to me? in terms of usually something has gone wrong with your transaction and your client's looking to you saying, didn't you know that XYZ? Didn't you know that the person, the person on the other side was, not legit, or the money's gone, or whatever, and they're coming to you. And that's usually when we start to have a difficult conversation. So in terms of how do you get there in terms of, I'm not kind of dealing with more of the technical things, but just in terms of kind of the know your client situation, how do you prevent that conversation where your client is coming to you saying, didn't you know? Didn't you know? And the question is, what is the standard in terms of how well do I need to know what's going on? And look, as a litigator, you're not going to like this answer, but it depends. It depends. What is the standard of care that you guys are being held to right now? And again, I think right now we're not being held to that high of a technical standard, but guess what? It's now considered best practices. And what's considered best practices today could become the standard practice in a few years from now. And you don't want to be that test case as to when that standard has changed. So we're just trying to get ahead of the game, get ahead of where things could become in terms of standards that are now standard in the UK and Europe could start coming over to our side.
I mean, if you were in the UK, for example, because of the high value of the assets and the services that you will deal with, you are subject to KYC and AML regulations. I'm not a UK attorney, so you should probably check one out. But what that would mean is, again, know who you're dealing with in terms of the actual individual, certified copy of passport, certified copy of utility bills, referral letters from financial institutions. The reason we ask that, or some service providers would ask that, is presumptively banks have to do their due diligence. So if they're willing to give you a referral letter, you're sort of the way there. And you could even go as far as having to ask for a statement of funds or financial statements. I've certainly gotten some from some of my clients when I have to get services for them. And so the fines over there can be quite large. In the US, for example, the main prohibition that we have is that you're not supposed to do business at all with any sanctioned individual. And so it could go as high as $250,000 per violation, with some criminal penalties as well.
Also, beware of the pushback, right? In terms of, even if you're doing things that may not be required for this transaction, but you still want to be abundantly cautious. And if you're getting hard pushback in terms of, why do I need to do this? This is just a yacht transaction, this is just this is, beware of the pushback in terms of, if there's nothing to worry about, if there's nothing to hide, and again, this is a very large transaction, things should start going off in the back of your head.
I mean, there should be no pushback. Most of your clients have been dealing with KYC related questions for 10 to 15 years now. Right. And their banks and the companies that open companies for them give it to them on a regular basis. Every 6 months they get a new KYC. So they should have it ready to go. You should not get any pushback at all. And the moment you get it, probably alarms should go off.
Exactly. And they should have a point person usually. If
they do.
You don't have it, then let me know who I should be speaking to that has all of this stuff already for you.
So the audience knows, we're wide open to ask questions. If anybody has any specific questions, you've got some excellent experts up here, and I knew Trish could kick this off.
So, is this on? Yeah.
Yes, it is.
I guess my question is, obviously, people of Russian background have to be checked for sanctions, but are there any other red flags that we should be looking at?
As far as Russians, unfortunately, even if they're not sanctioned, you might have issues, primarily with your own banks. I had a closing a couple months ago where we had wires held up for the better half of 2 months. And it took them that long to actually release it. The poor guy was not sanctioned or anything, but they didn't want to deal with it. And so you just have to be aware of it, that it may be an issue even if they're not sanctioned, unfortunately.
And are there any other red flags in terms of sanctioned individuals, or right now is that limited to?
So I would say that if you're dealing with somebody that is of what they call a high-risk country, so Venezuelans, Russians, Cubans, like actually from the island, your banks might be basically, it's not that you can't deal with it, but your own banks might not want to be involved in the transaction, and so that may affect your ability to deal with them.
Hi, my name's Annie McCorney. I just wondered, is there a financial point, like, is it $50,000? Is it $100,000? Is it $200,000? At what point do you think that the due diligence is required? Because much of what I deal with is $50,000 and less. Do you think that that is an alarm bell kind of thing?
So I think and again, not a European attorney, but I believe in the EU and the UK, there's like a 15 or 10 or maybe 20,000 threshold. But in the US, you're just not supposed to deal with any individual that is in a sanction list, whether it's 1,000, 2,000, or millions, right? But I do know that in the EU, there's monetary threshold, and I think it's around there.
And just from the U.S. standpoint, again, in terms of what can prevent your client from being upset, regardless of the amount, right? So, to some people, a $50,000 transaction may not be a lot, but guess what? To your client, it is. It's going to be a problem. And so I can tell you the best, a defense in court is, well, judge, it wasn't a lot of money. It's not going to go over well. So granted, there might be technical thresholds in terms of what's required, right? And we can always use those as defenses, but at the same time, the threshold to your client is 100% because that money's gone. So keep that in mind in terms of preparing your client for eventualities, in terms of, I think a lot of times it's managing the client's expectations, in terms of giving them a heads up, in terms of, yeah, we're trying to push this transaction through, but there might be some issues with the banks. There could be issues here in terms of just giving them a heads up, letting them know what things could be happening, takes a little hit off of their expectations in terms of you're managing the situation appropriately and you're letting them know that there could be some bumps in the road, but we're going to work our way through them.
Other questions from the audience? Hang on.
With regards to a utility bill or a driver's license, does it really matter which one we ask for?
So rule of thumb is you need a proof of identity. Usually that's your passport or a driver's license, right? And then the utility bill, it's really for the residential address. As far as the residential utility bill, phone, water, electricity. What I will tell you I have with a lot of my clients is they tell me, I don't actually have a utility bill that goes to my house. And so the answer to that may very well be that you need to ask for a bank statement or a certification from an accountant or a lawyer basically stating that.
But your driver's license has your home address on.
It's supposed to, but I can tell you from some of my clients, it doesn't always. And unfortunately, some of them will even acknowledge that they use an address because that's where they want to vote.
And I can tell you, even even our firm, we start getting mail from companies that aren't supposed to be using our firm address. So,
Yeah,
keep that in mind.
exactly.
We have been asked to supply a passport to banks in Greece this last summer in particular. How much responsibility do we have to disclose or to not supply that information towards our client?
So I guess it depends how much do they want to do what they want to do, right? So just like banks are kings in what they require. If you want to go on a trip to Greece and they're requesting this, then you need to provide it or they're not going, right? So I think when you first onboard them and start the whole process, you should tell them, listen, we may get a request for KYC, I need to have this on file. Do you have any issues with providing it if it comes to it? And if they do, then you deal with it then, and then you tell them if you have issues providing it, you might not be able to do this because it's a requirement on their side. And the reason is that they are subject to having more, they have more robust KYC and anti-money laundering procedures than we have over here, so that's what they ask for all of that.
I
And
agree.
I'm sorry about all these questions, but
No, you're fine.
should we make our client aware that we are supplying his passport to a bank in Greece?
So I think the best way to handle it is when you first start the process with them, you get all the information and you tell them, I may or may not have to provide this when as we complete the process, and that way they're aware, and if they have any issues, they tell you right then and there, as opposed to when you are way ahead and it might be a problem there, an issue.
I agree. I think timing is everything. Timing is everything. Just to let them know on the first opportunity when you're supplying these documents what's going to be happening to them and where it could be going. Again, it's about managing their expectations so that there's no surprises at the end, because surprises at the end is when people get really upset and start to call people like me. So first, at the first opportunity, let them know what's going to be happening.
Yeah, 15 years ago, not 15, God, I'm not, 10 years ago, I didn't have to tell my clients, I need your passport, I need all of this stuff at the outset because I'm going to have to provide it to all these kinds of service providers. Gosh, to even get an opinion on tax, you have to provide everybody on their mother's address, but that's where we are, unfortunately. And so they should have gotten more used to it by now because they have to deal with it on an ongoing basis with their banks primarily. And like I said, those are kings. So they're used to it, shouldn't be an issue. And if it is, you should alarms should go off.
Can I go?
Yes, please.
You mentioned the U.S. doesn't have as many, I guess, rules, but what if you're a central agent dealing with a European broker who says that they've done KYC on their client, and as you progress forward on this side of the world, what's our liability in that if it's fraudulent or it's wrong?
So,
And what do we ask for as proof besides a passport? And you said a certified copy, certified by whom?
okay, so one step at a time. If you all have, let's say, some of your brokerages have different offices in different jurisdictions, different rules will apply. And what might be okay over here, it's not adequate over there. So let's say another broker tells you, I did my KYC, we're good to go. Fine, give it to me. What did you do? And it shouldn't be an issue because they did their KYC, right? So what does it look like? Certified copy of passport, certified by an accountant or an attorney or a notary. Usually those three, right? In the US, a notary, it's not really somebody you think of as being difficult to get, but in Europe and other jurisdictions it is. So an accountant or an attorney may be more easily accessible. Same thing for the utility, certified by an accountant and attorney or a notary. They might have, at the fear of repeating myself, bank statements, source of funds statements. If you're in Europe, they probably did actually get a source of funds or financial statements. If they don't want to provide you with the whole thing, they can provide you a redacted version. And, if you run those individuals through the websites, like I said, OFAC has a website where you can search for sanctioned individuals. The EU has a similar, I think it's called EU sanctions map or something along those lines. And then the UK has one as well. There are people that might be sanctioned over here that are not sanctioned in Europe or in the UK. For example, primarily Venezuelans. Like, you can't transact business with Maduro in the US, but you might be able to do so in Europe. So just, if you have a presence in different jurisdictions, the best advice I can give you is make sure to hire an attorney over there so that they tell you what you need to do in every jurisdiction so that you're not in trouble in any of them.
And again, I'm kind of more on the side of, worst case scenario in terms of where does your responsibility end and the other side's, responsibility. And I think, again, from your client's perspective, I'm thinking, worst case scenario, when your client is accusing you of something, they're expecting you as a broker to be managing the entire transaction from their standpoint. And so when when the question comes, didn't you know this person on the other side was X, Y, and Z? And your response is, well, the broker on the other side told me everything was good. That may not be good enough. Maybe it would, maybe it won't. And guess what? We won't really know until the trier of fact says so. So I agree. Have the other side send you everything. Send me the file. Send me the Dropbox link or whatever. I had a conversation with a colleague of mine a few weeks ago. We were representing the seller, and he hadn't heard anything from the buyer's side, the buyer's lawyer. So eventually, the deadline is coming up for the conditional acceptance. He gives opposing counsel a call saying, hey, what's going on? I haven't heard from you on this transaction. The lawyer says, what are you talking about? What transaction? And he's like, I have a letter from you that says you're holding the buyer's deposit in escrow. And he said, I've never heard of that client before. That letter's a forgery. And so guess what? And that was on the other side. And there was no other side. And that transaction had been held up, and obviously, things will be happening. But just be aware, not only for your client, but keep in mind it could extend over to the other side as well.
Can I ask one more? Have you had an instance where, in our situation, we were representing the owner, the broker said they did the KYC, he provided us a passport. We consequently, realized that the passport was forged and messed with, so we kicked it back and said, sorry. But had that money come to us and we had done that charter, what's our, again, like what are the rules? What are the, what are the,
If you did,
I guess,
if you
what
would have-
happens then?
Sure. If it would have turned out to be a questionable individual or questionable funds, your liability could be civil and criminal. And so it sucks, it's scary, but yeah, it's what it is. I think in the U.S. you're basically up to 250,000 plus criminal liability.
250s in the U.S.?
Mm-hmm.
And again, that's if it was a sanctioned individual. If it's
Yeah.
just some guy that forged a passport and the money's gone, there could still be civil liability in terms of, the question is, what did you do? Was it reasonable? Okay, so we're not held to be, private detectives and making sure this person is a legit person. But at the end of the day is, what did you do to at least do your due diligence? And so if they provided you a passport, unless it looks really shady, you can usually trust the passport. But at the same time, you should know what a passport looks like. You should know, just kind of like you should know what a fake, $100 bill looks like or something if it's, not green. Yeah. So we're held to a reasonable standard, okay? Not, not the standard of a banking institution, at least not yet. So you can accept what reasonably looks like these documents, but at the same time, you're held to whatever knowledge that you do have. So if you worked with this individual before, that helps. If you've had notice of problems before, that doesn't help, right? So these are the factors that triers of fact, meaning a jury or an arbitrator, because now we have dispute resolution, these are the factors that they will be looking at in terms of, did you do your proper due diligence?
And to your specific case, That's why you ask for certified copies by a professional who we deem to be quote-unquote honest or honorable. It may not always be right, but that serves to protect you as opposed to just getting a clear copy that can be meddled with.
We got time for one more question. The other piece of this is, as Claudia said, 10 years ago it wasn't such a big deal, but we've all probably heard, it's not a teenage kid with a hoodie in his mother's basement who is trying to hack and make stuff up. There are office buildings full of people who are trained. They're 401ks, they've got insurance programs, they work 40 hours a week. This is real business that people are fabricating business transactions and trying to steal from you. So you have to be careful.
Absolutely.
Hi. I was just wondering if we should be concerned about guests of principal charter clients. So, for example, if we've done KYC on the principal charter client, but we are aware that maybe one of his guests is Russian or sanctioned, should we be concerned if we know that the money's not coming from them, but that they will be on board on the charter?
I think that is a very good question, actually. I think arguably...
You are judged by your peers.
I think arguably you may, because you knew, right? And then those guests may be providing some sort of payment vis-a-vis, what they bring, or who knows. So I think the rule has to be that if guests are coming and those guests are questionable, they shouldn't be on board.
My question is regards to APA. We often receive large amounts of APA, say $100,000 in APA. It just shows up in our account. We're not party to the contract. We have no idea who. We know nothing about this money. My firm's a yacht management firm, so we're expected to distribute this APA to the vendors. But again, we can do no KYC because we know nothing about it. So my question is, where does the rubber hit the road? Because it came from a known charter broker, is it their responsibility or does it become our responsibility because we received and distributed the money?
It can become your responsibility, I would think.
Again, from a litigation standpoint, once there's an issue with the money, you just follow all the points in terms of where did that money go and who along the way did their due diligence. So if you're in that chain somewhere, it's possible.
Because at worst case scenario, let's say that $100,000 came from El Chapo in Mexico, right? You're in trouble. It doesn't matter whether you were, the last vendor that got $10,000, you were giving services in exchange for that unclean money. And you could be liable.
Gosh, you could be such a downer at this time.
Sorry.
Morning.
Well,
but,
we never want
It's
to
all
leave.
Paul's fault. He
I
gave
know.
We never want to leave a presentation with a downer, and I think
Yes,
Claudia and Serena have done an incredible job up here. It's some very complex questions, and here's the good news. You are here. We're keeping on time, but I don't believe Claudia and Serena are disappearing anytime soon. There can be some follow-up questions, and thank you so much. That was very
thank you.
informative.
Thank you.
That was Claudia Casalis and Serena Whittier from about KYC.